All right. Thank you, everyone, for joining our panel today. The topic we have today is the impact of IP and diversity in the legal profession on society and in the practice of law. I'm excited with our panelists today. As I think I mentioned before, our final panelists will join us a little late, but we'll go ahead and get started with introductions. My name is Aneesh Mehta. I'm in-house counsel at Microsoft. As I said earlier, I'm actually now living in Hyderabad, India, where I moved about 7 months ago now, almost, to kind of start on a new role of supporting the India Development Center. But I started my career as a patent attorney at a small firm in Philly. I'm going to go ahead and let the panelists start by introducing themselves. We'll start with Anita, my fellow remote attendee. Can you give us your name, your role, and how you came to pick IP as a profession?
Sure. Hi, everyone. My name is Anita Lamb, and I am currently a senior corporate counsel at Microsoft. I support Xbox and a lot of the trust, safety, and regulatory aspects that are around Xbox. So if you have to deal with parental controls, parental settings, or content moderation, that's me. And prior to that, I was an IP litigator in DC and in New York at Mayor Brown and at Steptoe & Johnson. And before that, I got my PhD in biochemistry, and I didn't want to be an academic anymore. And I was like, man, what am I going to do with this degree? Because I also like money, but I don't want to. So I was just like, I can't be an educator or anything. So someone came to my school and said, you know, patent attorneys make some money. And I was like, well, guess I'm going to law school. And that's how I ended up here. I'll go to the panelists in the room.
That's fine. What were the three questions? So my name is Sean Suger. I am a partner at Winston and Strawn, based in Chicago. I forgot what the three topics were.
So it was your name, your role, and how you came to pick IP as a profession.
Okay. And I did not pick IP as a profession, though I did do a lot of patent stuff earlier in my career. I did cases for Activision, a couple of stuff against some patent trolls. But as I'm now a partner, I've kind of transitioned more to soft IP. So I'll do copyright, trademark, and I do a lot of defamation cases and stuff where we are representing people's interests and making sure that they keep their soft intellectual property and make sure they maintain their brand. So that is what I currently do, though I do have a background in patents.
Good afternoon, everyone. My name is Deng. I am an associate attorney at Fredrikson, Byron in Minneapolis, Minnesota. I sit in our tech and data group, and I'm a 2018 grad. So how did I become an IP lawyer? I took the scenic route. Immediately upon graduation, I went the regular commercial litigation route at a firm here in DC. Spent a couple of years as a government contractor with the Department of Justice. And that experience was over during the pandemic. And that was when I started plotting. I did pick tech. And I've been in my current role for a year, so I'm just learning how to walk in technology transactions right now.
That's all of us in the room.
Sorry. One thing you see immediately is that, like, I think everybody kind of came from different backgrounds and took a little bit of path, and we all have a little bit of different role in sort of the practice of IP law. And I think it's something that you don't typically hear about or see about in the media. So you know, it's not like Suits, it's not like Law and Order, it's not like any of the other shows. If we can go in like kind of the reverse order we did intros and just talk about what does a career in IP mean? Like, what does a day-to-day look like? Like, are you going into court? Are you seeing your clients on a day-to-day basis? Like, what do you do on an average day?
Okay, I'll start. On a day-to-day basis, my day doesn't usually look the same every day, but I do mainly two buckets of work. That first bucket is technology transactions, drafting and negotiating software contracts, professional services contracts. And basically what that means is any software that helps a business run, critical software, HR, payroll, things like that. We draft and negotiate those contracts. And then the second bucket of work that I work on is M&A support. So due diligence work, reviewing companies' IP portfolios, make sure everything is what they say it is, and sort of just dotting I's, crossing T's. And then a little bit of what else I do as probably a more junior person, which would more resemble what you all are closer to as law students, is whatever else anyone in my group needs at that time. So I do some copyright assignments, I do some trademark and patent assignments. I draft privacy policies that go on websites for businesses, terms of use, things like.
So,
one question. Do you know, it's kind of a sharp turn from the DOJ. A year in, how do you even begin to start working on those kinds of things, having done something completely different for the previous 3 years?
Yeah, so the learning curve is very steep. And I'm still in it right now. But before I even transitioned, I had done a lot of the research that a lot of the folks in the room were talking about prior to making that jump. So the entire time that I was working at DOJ, I was doing sort of my own homework on the side, connecting with Howard alum, other lawyers that I knew. I have members of my family that work in tech, so I talked to them quite a bit. My sister-in-law worked, well, she currently works in AI ethics and worked in privacy before. And so I was sort of just doing my homework a little bit before, asking people what their day-to-day looked like in the various practice areas. And so before even coming in, I sort of knew what the day-to-day would sort of look like just from conversations I've had. And in my past role at a different firm, I had done due diligence in like FCPA practice, so I was familiar about the process that way. But the learning curve is steep. But it's sort of a fun journey to be on. I think as lawyers, we're all pretty curious. We all enjoy learning. So every day is kind of, I learn something new. Some weeks I feel like, oh, I think I've got this. Other weeks I'm like, oh my goodness, what did I do? But I've been enjoying it.
Right, thanks, Sean. Sorry for interrupting.
No worries. So, when I was doing, I am not a corporate attorney. I'm a litigator. So most of my day-to-day varies on where a case would be. So when I was doing patent cases, I also, unlike Anita, I'm not smart. I have no technical background whatsoever. So part of my day when I would do patent cases, we would always start, Winston and Strawn is a big firm on trials and appeals. And so the first step for us when we would do, a bench trial in front of a judge in Delaware would just be to, as the trial lawyers, to figure out, all right, what is this? What is the technology? What is the basis for the claims? What's really going on with the underlying technology? Because we didn't know. And you don't have to know, but you do need to learn and be able to learn and explain it. And one of the things at Winston that we like is, we have to present to a jury. And to present to a jury, if I can't understand it, then they're not going to understand it. And, I think that is why we would win a lot of our patent trials for a variety of different matters. But otherwise, once you learn the technology, patent litigation is generally, especially when you get to trial, it's generally the same as any other case. So the first patent case I had was the lawyers came in with these huge contentions and validity, and I was like, I have no idea what any of this means. And so that was the first time I learned, the judges reading all of your work are going to not know anything that you're talking about. So the biggest important aspect as a person presenting these big, complex, if you look at a patent, it just kind of looks intimidating. The biggest thing is really learning how to distill it for a clerk who's 1 year out of law school, like the law students are about to be, because they're the ones who are going to tell the judge what to do. So my day-to-day was really just working with the tech team, because I was an associate at the time, working with the tech team and to get, explain to an 80-year-old partner how he was going to explain how the internet works or a video game works. That was the day-to-day for a trial. And then, the fun thing about trials and litigation is you go to trial a lot. Regular cases, you rarely see the inside of a courtroom. The first and second years at Winston, you know, I can tell you about, they go to 2 or 3 trials because they're bench trials and companies have money to litigate, and it's usually their IP, which is very important to them. So they are willing to do those trials and their bench trials. And so it's a really good opportunity to get experience in court, even get on your feet, argue a motion or so, which is very important to clients like Anita and Charlie. That's a trial, and then appeals are just briefs. It's the same thing. You write everything and say why you were right and the other side was wrong. So day to day is just talking, working, and hitting deadlines and going to the court and arguing.
So I agree so much with everything that Sean said, because I too was a patent litigator, and it was a lot of that like preparing for trial, getting deposition outlines ready so that you can do the deposition, so that you know what the facts are. Claim charts, that's like at the beginning when you're trying to figure out what you can even argue and what you can assert your patent on or your IP rights on. And then you get to experts, expert depositions, expert reports, all the types of pleadings and motions works that goes into that. So, you know, those of you still in law school, really get sharp on your legal research, because you're going to have to do so much case law research. It's like all feds all the time if you're doing patent law. And I do take issue with one thing that Sean said. Actually, 2 things. The first thing, just because I have a PhD, that doesn't mean I know anything. That means I know how to suffer, because that is what getting a PhD, it's just pure suffering. And that's what being at a law firm is. So if you're interested in suffering for money, you are in the right place. Second is the thing that I agree with Sean the most, is that the talent you have in getting that education is being able to distill the technology and the arguments down so that it's something that's understandable to a lay jury. And oftentimes that is understanding it enough to form an analogy to something else. Like one of the successful trials that I was lead counsel in, we were able to analogize a redox process for CoQ10 as a coffee maker and a coffee machine. And at that point, the jury was like, oh, I totally understand. And being able to make those parallels, real life parallels, is the difference between winning the case in front of a jury and not. And that was actually goes to, I think, your next question, Aneesh, which is a common myth as part of the IP profession, that you do need some kind of technical background. You don't. You need to be able to understand complex things, but that doesn't mean you need a technical background to do that. And so long as you have the ability and the desire to want to learn and to be learning new things and really delve into them and try to understand new things, asking a lot of questions, then I think you can have a profession in IP.
Thank you. And let me go ahead and kind of mix what the next question is in this current question. I think there's, you know, one thing that I didn't realize quite beforehand is, like, there's a difference between a trial lawyer and a litigator, right? There's a lot of litigators, there's very few trial lawyers, I feel like. In terms of the folks who are interested in going the litigation route or trial lawyer route, how much time are they actually spending in court in front of a judge, and how much of the time are they actually just spending writing? And like, how would you kind of view, like, what your perception was and what reality is on that area?
So my first trial I ever did, I was a 3rd year. I just finished my clerkship. We went to it was a really big defamation case, and we were going against a litigation firm. So Winston's a trial lawyer firm, like we go to trial, and then I'm going to explain the difference in a second. Then we were going against a litigation firm who shall not be named, and they would file papers every single day, just like nonstop. The judge would say, and then she's like, I really don't have time to do this because we have to do the trial. They filed 3 more motions, and she went off on them the next day. She said, counsel, I'm going to tell you an analogy that my mentor told me. Trial lawyers drink whiskey because they have to get up and speak in court the next day. And litigators drink wine because they stay up all night and write tons of papers and briefs. She said, I need all of you to start drinking a little bit more whiskey. And so that is the difference between a trial lawyer and a litigator. Trial lawyers, the law is important. I do not want to downplay that at all. But trial lawyers, you have to go to court. You have to get up. You have to have oral advocacy skills. You have to connect with other human beings. You have to talk. You have to take positions that, even if it's not what is going to be best, like the best legal argument, you have to say, you know, this judge just won't care, and I need to win over this other human being. So you might have to sacrifice certain aspects of your case, of your strategy, just to make sure you live to see another day. Litigators, and I do both. I can do both. Like litigators, you just make arguments and you preserve them for appeal, and I got to make sure I preserve everything. And the judge might have said they don't want to hear that, but I don't care. You file the motion anyway. But you know, you don't have to get up in front of that jury who's just been sitting there for hours, like they're missing work, they're missing their family, they're missing their kids. You don't want to be that person who's keeping them away from dinner or lunch. We literally will strategize, hey, let's cut off early today so they're not upset when they see the strategic witness. Or if we want to hide evidence, let's put it right before lunch when they're just ready to go. These are things that you have to really think about. We do huge jury research, like everything. Being a trial lawyer is about talking to people. And so I think, Aneesh, is that a fair difference between, you know, litigators can go to court, you might argue motion here or there, but on their feet every day and speaking?
I mean, I think it's fair. Anita, you were, I mean, I did litigation, but I was never allowed to speak in court. So I'm gonna let Anita, who probably did get to speak, answer on her view on this.
Yeah, I think Sean, you're spot on, which brings me, I forgot that the other thing I disagreed with on your original answer was that you said you went to court every day, and I was like, I never got to go to court every day. I only ever went to like 2 trials, but I was constantly working on motions, all of that paperwork. That's me. I'm the paperwork person. And you have a whole separate group of paperwork people that are doing all the discovery requests. And that is there. And those are, I never had to do that. The group I was in, we had like different sets of paperwork people. And it's like the people that had a technology background did a certain paperwork, and the people that didn't have a technology background did the other sort of paperwork. And it was all of these like motions to compel and really argumentative stuff. And like I sometimes would read their motions and I'd be like, oh damn, I really like that. I like how mean that is. I'm totally gonna do my motion later. But that is because in litigation land for a lot of IP matters, they go right up till the point and then they settle. So you don't actually end up going to court a lot of time, even though that's what the all the associates and partners want to do, because it's pretty fun. It's a lot of action. You feel like you're in the trenches. Once you go to trial with someone, like that is your like family for life, because you've been through some harrowing stuff together during a trial.
Yeah, I mean, I think my extent of speaking in a courtroom was I stood up, I introduced my name, Aneesh Mehta, for this client, and I sat down, and then the partner said everything else afterwards. So that's as far as I go.
It's funny though, because honestly, I remember the first time I had to introduce myself in court, I was terrified. I literally just ran over. I was one of the paper lawyers at the time. I ran over to take the trial lawyer, like the briefs, and then they're like, counsel, introduce yourself. And I was like stuck at counsel's table. And then, so and I do this now to associates because I mean, like, you gotta like speak, you gotta get over your nerves. I stuttered. So I was like, my name is Sean Suber. We represent, I didn't know who we represented. I was so nervous and it was so bad. And I was like, I'm never like, always be on your toes. You gotta just be ready. And then, you know, I do that now to some people, like we'll be in a deposition. I'm like, introduce yourself. And, you know, just because you have to be ready, like you don't want to just be that person behind the scenes. So you got to always be ready and stay ready for your moment.
Yeah. So let's talk about like myths of pursuing IP. And I'll tell you that my first one is I remember, I started my career as an engineer, and I I quit my job and I went back to actually grad school, and it was for the probably seemingly the dumbest reason you could imagine. My alma mater was preseason #1 in college football. I wanted to be back home. When we win a title, so I went back and I left my job, and a guy I played basketball with for like a couple of years came back and said, "I heard you're leaving." I said, "Yeah." He said, "Have you thought about career in IP? Did you know about patent law?" I said, "I heard it was boring." And that was, I was just talking to a guy I knew from the basketball. He goes, "Did you know I'm the company's IP attorney?" So, no, I did not know that. And then they actually pulled me aside and actually talked to me about like what it looks like and what the day is. And I had like no concept of what being a patent lawyer was until that point, right? All I'd heard was like some vague thing of what like, patent was. And so that was my first myth of like what life is. Like, what are some of the myths you've heard and like that may have dissuaded you early on from a patent career or IP career, or that ones that you still hear today that you think would be helpful, or ones that maybe if you knew you wouldn't be an IP right now, or something like the upside or downside?
So I guess like we've already discussed the first myth, which is that you have to have a technical background, which you just don't. But I think for me, the myth, and I'm really figuring this out now that I'm a partner, a myth in my head was that, if you want to do IP, it's all patents. And if you want to like get into the IP world, you got to do patents. And I look at that as like hard IP. There's a lot of work in soft IP for, copyright, trademark issues. And I'm learning that now as a partner, because a lot of the people that I speak to, those are the issues that they have, because I speak to diverse attorneys and diverse people. And those are the challenges they are facing. How do I trademark this concept? How do I have this really great idea and I just want to protect my IP, my intellectual property. And we actually have a really big trial, we have a big trial right now at Winston. And I'm not sure I can even, I guess it's for saving, it's basically about the IP of, a very big entertainer, African-American, and their IP, another company decided to make dolls based off of their, their group. Yeah. And it's a really big deal about race, what comes into play when, ideas are taken. And, the court is understandably trying to straddle that very difficult line of like, where does race play, if at all? And so it's a really big deal. Those are cases that I think diverse lawyers have a very impact. It's one thing to have a bunch of old white guys up there saying, "Oh, this is very important." It's another thing to say like, "No, this is like a historical thing, and this is important to the community." Like, these are things that people argue all the time, that we all know that people argue all the time. And I'm now learning that soft IP is a lot more important in the grand scheme of IP than I thought. Oh, the way you make all the money is just doing.
There's nothing soft about it, man. Nothing soft about it.
There's nothing soft about it. That's the best way to put it.
Yeah, and I guess I can echo what everyone else already said about just sort of that myth of you need to have a hard science background to get into the space. And I guess I can talk a little bit about how sort of I went through law school with that understanding, and really just never looked the IP way. I never took an IP class. Anytime people were talking at a panel and they were talking IP, my ear just kind of shut down, because that wasn't the route that I could take, right? And so that was just never an option. I think a panelist earlier said something along the lines of, we've got to be in the rooms, but you need to know the room exists. The rooms are right next to me, but because of that myth, I just didn't know that was a path that I could take. And I also thought it was just like hard patents, like research development, things like that. But in my specific practice, I touch a little bit of everything, being so junior. there's a data privacy space, drafting agreements there, data transfer agreements. There's the technology transactions where you focus on the risk allocation of IP. It's not as important to know how like intense the technology actually works. But I had a judge say to me once, and I'll steal this from your book. When I was exploring going to law school, I had a judge say to me, well, are you sure you want to go to law school, or are you sure you want to be a lawyer? Being a lawyer is like doing homework for the rest of your life. And when I was transitioning from my prior roles to this role now, I was like, well, I told the judge I liked homework, so let me just, deconstruct those myths and learn what I have to learn to get in there.
Anita?
I think that for the both soft IP and tech trans are really important elements of different practices, and that they should be seen as all part of the IP umbrella, whether it's copyrights, trademarks, trade secrets, and the tech allocation in transactions. I tried to do all of that during my time because I knew that there was such a wide breadth of IP that you could perform. And the trademark and copyright elements are the ones that are more real life to me. Like, oh, I totally know what that brand is. Am I likely to get confused between this brand and that brand? Is that what they wanted me to do? Was that the point? I think those are really interesting questions. And in terms of the IP rights that are involved in entertainment law, like music copyrights, there's like 12 different kinds of copyrights for one piece of music. And if you are going to be representing an artist and you sign over their records and their rights, like you are losing them a lot of money if that's the way you're going to go. So knowing these types of things makes you stand out as someone who can be all encompassing in how you're representing your clients. And if you ever want to go in-house for something at a tech company, they definitely need you to understand licensing, any kind of inbound or outbound licensing. And that's where IP tech trans experience is really important.
Yeah, and I mean, to be honest with you, I've tried to go away from my like caveman image of hard IP and soft IP, right? Like I think as we look at it right now, right, like we're like sort of on the precipice of like the big tech change, and like we've been hearing about like large language models and chatbots and AI and all this kind of stuff, where it's pulling large amounts of data from one place and packaging up in another, and it's going to cause all kinds of new IP issues, which would traditionally be viewed as, under the soft IP realm. It's copyright, it's all kinds of, trade secret, all kinds of issues that may come up. And so that's going to transition to like our next question here is like, in really thinking about how emerging technologies are going to change the way we work, change a lot of how we work in the way the cell phone, the smartphone changed everything in like 2007. We'll start with the fact that like the legal profession, IP profession, not particularly diverse, not always like supportive of diverse communities. As we're looking at tech change, how should our profession respond to emerging technologies in a way that's going to promote diversity and equity?
I can start with that as I think that the first thing we need to do is make sure that all of the baselines of these technologies, like the AI, that they're being trained on data that is diverse and that unbiased, because it's like the representation of the data in the models, and are they even accounting for people of color, for women of color, for all people of all backgrounds. And like a real life situation would be autonomous driving, and the data upon which models that are used for autonomous driving purposes are being used, and that's where they're training how their algorithms are going to look. And if you're training this autonomous driving software and it only recognizes like a white person on a crosswalk and they stop the car there, but they don't account for other people that may have darker skin, and then the car hits them, that's real life consequences of data, of biased data upon which AI is being trained on. So I think my view is more like of the development of the technology first.
And what's your role as a lawyer in influencing that?
Keep bringing it up, like, oh, interesting data set usage. Do you know anything about it? Where'd you get it? Who's in it? What's in it?
Yeah, and I think so. I think the point, Aneesh bringing up right now is that we're in an area where the technology is out a little bit in front of the law, and so we're at the stage where we have like ethics and rules that we apply before like something bad happens, and then the regulators put down a law. So you have to kind of start thinking ahead of like where can go wrong, and how do we set rules in place, for our clients in advance of just what's out there in a written case law or written like bill or law or something passed by the government. And sorry, the panelists in the room.
I think that's a good segue. Like the rules we have, what rules we have, how do we do it? I think it was this week. Time's a construct. It's either this week or last week. The Supreme Court was just looking at Section 230, what it means, how are they going to like expand any liability for Section 230 and make exceptions, or if they're just going to punt it to Congress. And then if you listen to the arguments, they very clearly like, we don't know what we're doing. This is not for us. This is just not for us. And then
we're afraid we're going to break the internet.
Yeah, we're going to break the internet. And then I'm laughing because, Section 230 is a law that was passed in the 90s. And that's governing how we deal with the internet in 2023. And, so I'm a very big person and proponent of like the solution is really staring us right in the face. If you're working with 1993 laws for the 2023 internet, I think 1990 we still had dial-up with AOL, and like if you couldn't be on your house phone and the internet at the same time. And so,
they don't know anything about that in that room, probably, man. They weren't
right.
born, right?
Right. And then like Aneesh, your point, like we have Chat GPT, and that thing is talking about like, it wants to be human, and it's like it's scary, but at the same time, it's pulling data from everywhere. So what do we do if I'll say what if we do if said tech company X has a chat bot or an AI thing, and it decides to pull an entire idea from the internet, because all of our stuff is on the internet, and that's my idea. And like they draw these pictures that are really cool on Twitter and Instagram, and I'm like, wait a second, that's my idea. That's my work. It's pulling from all of us. Where do you get to protect your information at that point? If it's all just everyone's and it's free source, I don't think that's the general idea. That's not how copyright's supposed to work. That's not how your personal beliefs and ideas are supposed to be held. And that's something Congress is just going to have to do. Now, I'm in DC. I know Congress won't do anything. So eventually, that's something that's just going to have to be done. What can we do as lawyers? We can, in cases like this one, I think a lot of lawyers did. I read an amicus brief. People were talking about like, algorithms and how they can do real harm to minority communities. And there's no real way to hold Company A, there's no real way to hold Company A responsible if this algorithm's doing it, because there's a whole law that literally says you can't sue them. So what incentive do they have to stop? So, just pointing that out, like Anita said, but like forcefully, like these are gonna have dire consequences, write about it, just put it out there so you can be like, I told you so. When it comes due, because Aneesh, you are right. It's going to be a lot of issues in the next 5 to 10 years, 2 to 5 years, with how all of this data that we all just give up on a daily basis without really knowing it comes back to haunt us. How we are, fed different information based on what we do, where we are, who we communicate with, and it's dangerous, it's scary, but it's also very promising. It's an opportunity for great change to bring us all closer together. So that's something we should be on the forefront highlighting every chance we get.
Yeah, I mean, I agree with everything everyone has already said. When I was looking at this question before the panel, I was thinking about an area of research that I've been kind of looking into. Then I do whatever people send my way. And it's the area of like website accessibility, right? So, and digital accessibility for folks with, for ADA compliance, right? Folks living with disabilities, whether your websites have screen reader technology. And so when thinking about that, as someone who does not deal with that, but I deal with those cases, I think about engaging with those communities and those advocacy groups that are doing the policy level work for how companies should approach how to run their online presence or their digital presence, even physical digital things, right? So like if you go into a retail shop, how is it that a person with a disability is able to check out the same way that you and I can, right? And so I think us as lawyers, we have wide networks, right? But then also I think it's on us to engage with the people that are doing the work on a daily basis to like actually make it.
Right. And so I think now we'll go to what we call lightning round. You know, we're talking to a bunch of law students. They're trying to figure out what their career is, how to get to where they want to get. Like, look, I think a lot of us, it sounds like we've all at least made one switch in our career, whether it's from DOJ to IP, whether it's from patent litigating to like trademark copyright focus, or whether it came from a PhD to litigator to in-house. There's always kind of the switches. What's like the one thing you wish you would have done in law school to prepare for a career in IP? And whoever wants to jump in first, go ahead.
I can do that. I think that in law school, I had the group of friends that I really liked and that I always hung out with. They were in my section, and I was a part-time student because I was working at a firm while in law school. And so yay to all the part-timers, if there are any in there. So I, found the people that I hung out with, went to bar reviews with, had study groups with. I wish that I had branched out more and had gotten to know other people in my law school class more, because you need to be networking. Like, you're doing a great job networking now, but you need to not only be networking with people in the places that you want to be at, like us law firm attorneys or us corporate attorneys. You need to be networking with the people that are your peers, because as you rise up, they rise up. And you don't know who's going to be the law firm associate, could be you, that you see your colleague, your classmate go in-house at a new startup, and you're like, could be doing some business, could be trying to make partner here. You need to start those relationships early, and try not to burn any bridges. Try not to behave in a way in law school that people are like, oh wow, you know who I will never send work to? That person. So keep it together.
Don't burn bridges. I'll pick up there. Everything you do, law students, you are now, this is your professional career because these are your professional colleagues. So don't burn bridges. I think, so I went to UVA. Sorry, UVA, but it's in the middle of nowhere. So, it's not that many, like, doing what you're doing today. Come to an event at Perkins Coie and find out about IP law. Like, this is like a first step, like, that I really wish I would have done. I just couldn't because I was in Charlottesville. If you're like in DC, you're in the heart of it. Going to these events, meeting people, talking to partners. Because if you look at a law firm website, we are the top firm in litigation and transactional and regulatory, and everybody's the best at everything. But it's literally not possible for everybody to be the best at everything. So, like, actually talk to people on a one-on-one level. Like, what do you do? That's why Aneesh started and said, what is your day-to-day? Because that gives you an idea. Like, when people told me when I finally figured out what a corporate attorney did, I was like, this is not for me. It's no legal research. It's just not for me. It's just not for me. And a lot of the places I was looking for the summer, I was like, it was like these huge corporate firms when I really didn't need to do that. That's not what I wanted to do. That's why I ended up clerking, because I wanted to do litigation. But if you just look, you don't have other people to talk to, everything will come across the same. You're like, oh, I can do really big litigation at this white shoe, New York, Manhattan corporate law firm. And that's not how it's going to really work. So take advantage of the fact that I grew up in the DC area, so you're in the greatest city in the world, and meet people, talk to people. And I think I would have done that if I were in school here, for sure.
Yeah, same points there. I think during law school, I was very involved, right? And so I did a lot of externships, did an externship at the bank, met a lot of people, networked, but I was very focused on one specific route that I was going to take. And I didn't really give any thought to anything else at that point. But like how everyone already said, your classmates are your peers and they're gonna eventually be your colleagues. And when I was making my transition into IP and tech, I called friends that were in this space. I reached out to Charlie. I attended the first IP conference just out of curiosity in 2019. And then once I attended that, I was like, oh, maybe I'll go this route. I'll talk to this person that I met here. And then the year after that, I just kept narrowing down what exactly it is that I found enjoyable, because at this point, I'd been practicing, I'd been working already, knew what I enjoyed, what I didn't. But yeah, really just staying connected to people, and then don't focus too much. I feel like that's one thing that if I could go back again, I would take an IP course.
I'm going to give two things. One is like never talk to any of your classmates after exams and ask them how they answered an exam question. Like it's never going to end well for any of you. They're going, oh, you got this totally wrong. You missed the issue. So never, just once the exam's done, just forget about it. Let it go. The other thing is really, it's something for like law students and, newer attorneys. There's sort of like these unwritten like rules of etiquette and just kind of ways to behave, right? And as odd as it is, like the one thing I like, you're law students, you're looking for jobs. If you're a lawyer, you're looking for clients. If you're looking for a job and you meet somebody, don't just go up and ask them if they have a job. Like it just makes the conversation awkward. So like the way to do it is saying like, yeah, I'm looking around for jobs. It's a little bit, it gives them an out if they don't have a job, but like I say, it just works easier if you kind of let them know that you're interested, you're looking around, and you can ask them for advice on looking for jobs. But it can get, a lot of people will like recoil if you just say, are you hiring directly? Same thing is like, once you're like a young lawyer and you're looking for your clients, like people don't typically come out and say, can I do work for you? That's just like, let's get to know you first. And like you build up to it. And like, they know you're looking for a job if you're a law student, they know you're looking for work if you're a law firm or you're in-house, but like, it's like this unwritten thing that you don't typically just go out and ask up front. And I'd say that's like my main one, because that's one I think particularly when it's like law students looking for jobs, it costs them a chance, because a lot of times the person you meet won't be the one who has a job for you anyway. So it's like, you just should tell them you're looking for one. And a lot of people will then actually be on the lookout for you and say, okay, you know what? I don't even have this role, but my friend Sean and Winston, he's got a lot of trademark cases. And so I'll introduce you to him. And it makes it easier for them to transition and help you, as opposed to the direct ask of, Anita, do you have a job for me? Right. Like, so that's my big one.
Yeah, I would add to that as law students, if you are looking for a job and we just meet, come up, say hi, my name is X. I'm a 2L, 3L at Howard, blah, blah, blah. And then, don't just say, and I want a job. Now, I really don't. I was like, great, let's find you a job. Others do care. Like, it really does bother some people. And, a lot of people think, oh, if you ask somebody black and they're black and they have a job, like, not everybody thinks that way. It's just don't think that everybody thinks that way. Read the room, read the person. Like I just said, like if you want a job, I might not have a job. I don't, but I can help you find something. I can say, hey, here's a 3L job. It might not be a big law job. And that's another thing. when somebody like, if somebody tries to help you and it's not what you want, then don't ghost them, because then I'm telling you right now, as minority lawyers, Black lawyers, it's only but so many of us. So I will end up seeing you again. And then it gets even more awkward, because it's like, well, you asked me to help you. I went out my way to help you. And yeah, I couldn't get you the job at the #1 law firm, but you know, law firm number 251 was right there. And they pay money. And you just didn't even ask. And now I look like a jerk because you didn't even follow up. So, you know, even if it's not what you want, follow up, because like relationships really, 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 really do matter. And I know I don't personally hold grudges. I remember stuff, but I won't hold a grudge. Other people hold grudges. I learned that. People, one person who shall not be named, I was like, it was a client of mine, and we were out at a conference. This is an older Black man, and this guy came up to him and they were talking, and he just gave him the utmost cold shoulder. He's like, yeah, that guy didn't give me a job 30 years ago. I was like, dang. 30 years ago? Like, he remembered it to that day. I was like, okay. Well, so it's important to, like, you know, I'm expecting these two old men to say, hey, you know, like, no, he was not having it. He was not happy. So, you know, it matters. Make sure you, like, relationships really matter. They really do.
Also, jumping off of that as well, I think one important thing to note is you're not looking for just a job. When you're meeting people, relationships actually matter, because the conversations that you have, whether it's a 30-minute coffee, an hour-long lunch, or you actually begin to develop a mentorship relationship or even a peer relationship with someone, your focus should be sort of like your long-term growth and how that conversation fits into that. And then also just getting to know people as people. I think that's really important, because we do the work we do because we find genuine interest in it, right? So just finding like-minded people. Some might be your peers, some might even be younger than you, some might be some of the folks you had here today, where it's like you're kind of intimidated to even speak to them. But you have something in common, which is a general interest, and just creating real human relationships in that way, I think is important as well.
Yeah, I
We're
mean,
supposed to talk. Let me give one. I want to do an analogy. An analogy. If I am looking for work, right? You have to be strategic how you approach people. If I don't know, I'm going to use Charlie since everybody knows Charlie. If I don't know that Charlie can give work, I'm wasting my time to say, Charlie, give me work, because I just don't know. It's a lot better to just meet Charlie, say, hey, Charlie, how you doing? You want to grab a drink, blah, 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 and then find out more about him. You'll quickly find out whether he has the power to give somebody a job or hire somebody. And then you'll also figure out he will know who does have that power. And you say, oh, you mentioned the hiring partner. Do you know him? Did you introduce me to him? Those are the ways to like use a situation in your relationship that you build organically to get the long game, basically, as we were just discussing. I just want to give one example, because that's one way you can do it, aside from if you got work.
All right. Well, you know, I want to thank the panelists for all their their time and their thoughts today. I do want to leave it open for some questions. So I can't see the room or if hands are raised, but if there's a moderator or something, do they have any questions for the panelists, folks in the room?
Yes, ma'am.
I have two completely unrelated questions.
Uh-oh.
So the first question is about like employment. So each of you talked about a transition. Our generation is known for switching jobs every couple of years. In the legal industry, I'm curious how is that looked upon? I've met people who have one perspective. They're like, I've stayed at this place 10 years, and if you be a partner or whatever, you have to stay somewhere for that long. Or is it, frowned upon in the legal industry? Is it normal? Or how difficult is it to do?
So I'm on the hiring committee at my firm, and I can say I personally don't care. I will say that other partners and people at like NALP conferences, a red flag will fly up if somebody's like, let's pick a 6-year associate and they're at like firm 4 or 3. They're like, why do they keep leaving these firms? Now, some people have legitimate reasons. I wanted to do X and that law firm didn't have practice X. So that's why 1 or 2, maybe 3 changes make sense over the course of a career. But, you know, like if somebody's a 2nd-year associate and they're on their 3rd firm, they're like, wait a second, that raises a red flag. Because it's like, why, what is going on? So if that is the case, but I don't think you should be scared if you're somewhere where you don't fit, it's not working for you. I don't think you should stay just out of optics.
Yeah, now I'll give from the perspective of why the employer, particularly if you're a young lawyer, the law firms put money into training you, right? Like to get you up and running as a lawyer. And so they look at it as a cost of like, is this person going to leave? It's not so much that they care about what they did before, why they changed. It's like, but if I were to invest in this person, are they going to stay long enough that I can recoup my investment? And so like, if you do it, just have a story, right? Like it could be, look, I got married. I went back to look after my family. I did this, or I did something. Like, as long as you have a story of why you did it and it makes sense to them, good. But if it's just somebody who like every 6 months just decided, I didn't like this one project, or I didn't like this, and I just left, then that's gonna raise the flag. So be able to have a story if you are moving that much.
And frankly, this career, like they pay a lot of money because these jobs aren't exactly the most fun. And so, you know, how people will deal with adversity, you know, that's one thing that people will say. That's like, oh, maybe they're just leaving because they're looking for this ideal unicorn that just doesn't exist.
And then my other question that wasn't related to that question is about IP liability and like enforcement and how it's changed. So I'm curious about like now we're seeing a lot of like, for example, I did a lot of research in my last semester about Roblox. And like there are these platforms that allow users to make games or create content to put on those websites that may use IP from other companies. Like you can go online and make a Frozen game now, put it on Roblox. And I'm curious to see, like, with the advent of technology like that, are we seeing shifts in who IP is holding liable, whether it's the company, whether they're holding the company liable for what the user puts up, and then I don't know whether Section 230 applies here at all. But I guess that's my question is like, with these new technologies, are we seeing shifts in how IP is enforced?
Do we have a gaming attorney on the call?
Yeah, I'll comment a little bit on that. I think that for your example of Frozen, there is no way that there's a Frozen thing on there because there is no more litigious party than Disney. You put any Disney thing out there, it's gone. But you know, that's their right. They are very protective of their IP, and with good reason, because they have a lot of it and they make a lot of money off of it. In terms of enforcement, I think that it'll depend on what the license terms are, if any, that the platform has for developing on said platforms, and if they allow for the creator to have IP rights, and if the IP rights are, if the platform even has the information of the developer or of the creator to share with the litigating party, then they could pass it through, and that should generally be in the terms of service. So I think it'll depend on other types of platforms where perhaps they don't have clear terms of services, and also the plaintiff will usually look at the party that has the deepest pockets and like who they're going to try to get recoup from in this type of circumstance.
Thank you.
Any other questions in the room?
I think we're done.
Cold bench.
Thank you, Aneesh, Anita, Sean, Naya, for that discussion. As you can see, you had a lot of crowd participation. We appreciate the realness.